Today, Waqf is the third largest landholder in India after defense and railways. Derecognize the grants which have been made by the conquerors, the erstwhile invaders. This land was never theirs. So why should we recognize their grant? So Waqf otherwise also had created lot of problems during freedom struggle. And we find that the British government had brought in all these Waqf acts with a view to create alliance with Muslim League, to build up Muslim League, to create its strength.
Hello everyone and welcome to Verdictum. Today in our In Conversation series, we are honored to have with us eminent senior advocate Mr. Rakesh Dwivedi. A heartiest welcome, sir.
Thank you.
Sir has more than 20 years of extensive experience in practice both at the Allahabad High Court and in the Supreme Court. Sir started out at the Allahabad High Court in 1975 and later, after being designated as a senior advocate, Sir shifted his practice to the Supreme Court in 1997. Sir specializes in civil and constitutional matters. Sir has also served as the Additional Advocate General of Uttar Pradesh. In the recent times, Sir has given his appearance in the prominent matters such as the Aadhaar card case, Article 370 abrogation, same-sex marriage, Aligarh Muslim University status issue, electoral bonds case, and others. Today, we are going to engage with Sir to talk about the Waqf Amendment Bill of 2024. The bill was introduced a month prior on August 8th. It carries a total of 44 amendments to the original Act of 1995. So let's dive into it. Sir, let me begin by asking you about the fundamental difference between the existing Hindu religious endowment laws and the Waqf Act.
See, so far as Waqf Act is concerned, there is much greater protection and much more powers to the Waqf board with regard to the management and control over the Waqf is concerned. So there is more autonomy, more freedom, and the power extends to this extent that whatever survey they do and on the basis of which they can just lay their finger on any particular property and say that it is Waqf, and then the burden is on the other side, other person who thinks that property belongs to him and he has been in possession over a long period of time. So it is the burden shifts on him. And curiously, there is no limitation period. So even if you have been enjoying the property for 50 years, then also the position is that the Waqf board can declare it to be a Waqf property. And your only option is to go to the Waqf tribunal and establish it to the Waqf board and establish your rights. If you are aggrieved, you go to the Waqf tribunal and their decision is final, and then your only remedy is that you go to the writ court, which has a limited narrow jurisdiction. So the civil courts are barred. And the expanse of Waqf is very wide. There is Waqf by user, there is Waqf by oral creation. So the powers are very wide. It includes all kinds of grant which they say, sometimes they say have been given by the sultans, sometimes by the Mughal Badshahs, by the governors of Mughal Badshah, or the Nizams and Nawabs. So all of whom were invaders. But yet their grant is recognized. So the width and expanse of the Waqf management is completely different. And as when you come to the Hindu Devatar properties, temple properties, etc., one finds that in most of the states there are Hindu Endowments Acts where virtually the entire control vests in the government. And the government manages the commissioners, the collectors, the deputy commissioners, and they are the people who appoint the archakas. And so they have all their fingers 10 fingers into the trusts which have been created for management of temples, etc. So it's a complete contrast. So something very curious that even after independence, this kind of situation is continuing. But that's the position, and the Hindu trusts, they hardly any autonomy. The freedom is very restricted, and there is complete control of the state governments.
So I was following up with the last question, sir, that there are no special laws for Christian religious endowments. So is treating endowments of different religions differently? Do you think it's a violation of Article 14?
So yes, it's a discrimination. There may be different laws for Hindu trusts and Muslim trusts and Sikh and so on, because the history is different and the religion is different. So since the trusts are created for religious purposes, therefore the laws may be different, but substantially they should be having the similar kind of autonomies and regulations and restrictions. But here we find that there is so much of difference, which is clearly discriminatory, and it is appears to be hostile discrimination. So it violates Article 14 for sure, this kind of situation.
Should the Uniform Civil Code be extended to religious endowments also? If yes, which model will you like to suggest? The Waqf Act model, the Hindu Religious Endowment Laws model, or the no inheritance model applicable to the Christian community?
See, Uniform Civil Code is a wider issue. It covers so many other things. In particularly, the focus is on gender justice in the Uniform Civil Code.
Yes,
Of course, there are other things, but the focus is on gender justice. But so I would think that there would be, and there used to be earlier, there are enough provisions for managing the trust. So the Hindu trust, Christian trust, Sikh trust, Muslim trusts, all of them, religious or charitable, India certainly should have one single law. And there can be distinctions. But even as I said, even if there are different laws, substantially they should provide for same autonomy, same freedom, same regulation. So the issue is not so much that there is one law or several laws, but of substantial similarity, substantial freedom, substantial autonomy. And there is no difficulty in having one law also.
So do you think that the ambit of Uniform Civil Code could be expanded to it to touch upon the endowment issue as well?
I think it would be appropriate to deal with this aspect separately instead of clubbing it with other issues, because UCC is a wider issue and it involves gender justice and other aspects of like inheritance and marriage and so many issues. So it becomes more complicated. So it is better to have a law relating to religious and charitable endowments.
Yes, sir.
But more important is that even if you have separate laws for religious considerations, even then there should be substantial similarity in matter of autonomy and freedom and regulation.
Yes, sir. Yes. So I would like to ask you next is what, according to you, are the problems with the Waqf Act of 1995, which affects the rights of the citizens belonging to the other community of the country?
See, problems are many, but according to me, the basic problem is that unfortunately, even after independence, we have continued to recognize the grants of land by the sultans and the Mughal Badshahs and their governors and Nawabs. So the result is that those forces which had invaded India and occupied India for a long period, they actually did not own the land which is our territory. They subjugated the people of India and they took advantage of the land which did not belong to them. Waqf can be created by somebody out of its own property. I can create a waqf with regard to my movable, immovable property and dedicate it to the God for religious or charitable purposes. But I cannot forcibly occupy somebody else's land and then create a waqf on that. So that grant is recognized by these acts, right from 1954 and 19 amendments and then 1995 Act and the 2013 amendment. So this is the basic problem with this. Not only the grants, but there are certain common lands, Shamilat De, Shamilat Patti, which is common land of the villagers. Even with respect to them, Waqf has been recognized. There is evacuee property, which is on which the people who migrated from Pakistan during partition and they were enjoying that property since long. Even that is included in the Waqf. So Waqf can spread its tentacles on all these kind of lands. So that's one basic problem with regard. Second problem is that if the Waqf board has very wide powers and they can make such survey as they want and then declare any property to be their own. And today we find that in Tamil Nadu, the whole village has been declared to be Waqf. Even though there are temples and majority of people are Hindus, but that is Waqf. There are cases like Delhi, there are 70% of the area will be Waqf. So likewise in several states, these are the problems where public property, municipal properties, courts and all those, all lands become part. And today Waqf is the third largest landholder in India after defense and railways. So I mean, this is a very serious matter on which the parliamentarians should give serious consideration. It is time that we derecognize the grants which have been made by the conquerors, the erstwhile invaders. This land was never theirs. So why should we recognize their grant? And the government is the owner of that land, the grant can be undone. Recently in 2016, the Supreme Court has taken a view. Justice Hemant Gupta has delivered a judgment where they have said that the land which belongs to the sovereign, the grants can always be undone. Now that was also a case where in 1912, since 1912, the government was recorded as owner. And after several years, the Waqf board declared that it is a Waqf. And they issued an errata, a correction notification. Earlier, their land area mentioned was only a few bighas. But by this correction notification, after several years, they said it is now 1,600 acres. As a result, the government land, which was recorded as government since 1912 and which had been distributed to various public corporations, all that stood covered. So the Supreme Court said, no, that all becomes that Jagir, etc. The grants go once it has been nullified. So it's very clear law now that the government can nullify these grants. And there is no need. And that is not anti-Muslim either, because Muslims are free to create Waqf out of their own property. So if any Muslim in India wants to do that, he is free to do it. No problem. It is consistent with their religion. But there is no question of banking on any grants made by the erstwhile Badshah and Sultans and Nizams and Nawabs. So Waqf otherwise also had created a lot of problems during freedom struggle. And we find that the British government had brought in all these Waqf acts with a view to create alliance with Muslim League. to build up Muslim League, to create its strength. So, especially after the Government of India Act 1937, Muslim League did not do well in the elections. Then we find that Bengal Odisha Waqf Act was created, Bombay Waqf Act was created, Bengal Waqf Act was created in 1934 to 1936, and Sharia Act was imposed in 1937. So this was all done, and we see that Lahore Resolution came in 1940, and that all led to partition. So Waqf is not such a benign kind of a thing. Although under the constitution it should be benign, but its history is cancerous. In the name of Waqf, there have been conversions. In the name of Waqf, there have been partition of India. The whole effort was to create a unity amongst the Muslims behind the Muslim League. So even after this, unfortunately, the previous governments have not bestowed due attention, and the result has been that we are still recognizing and expanding. Now, why should a common land be included in the Waqf? Why should evacuee property? But all this has been done under the 95 Act and the 2013 amendment. So I would say that this is a very serious problem, and the JPC is meeting. I would request the honorable members of the JPC and the parliamentarians to include a specific provision to undo the grants of the Mughal Badshahs and the Sultans and the governors and Nawabs. And they should take out this Shambhala Day, the common land provision, from the definition of Waqf, and leave the Muslims free to create their Waqfs. No problem in that. So there's no need why anybody in India today, be of whichever religion, subscribing to whichever religion, should look to any grant by the Mughal Badshahs or the Sultans, etc. So that's the problem, and I hope the bill which has been presented in the parliament requires changes in this direction. It is a welcome bill. It is now giving power to the civil court to intervene. The Waqf tribunal will no more be final. So all those steps are good. But unless this is done, unless the grants and this common land is taken out of the definition of Waqf, the problem will not be solved.
This was my follow-up question, sir. Whether you see this particular amendment curing these defects to some extent. The act, which is the amendment.
That's what I want. Let us see whether my voice reaches them. It's up to you people to ensure that the voice reaches them, and then it is for them to consider.
Yes, sir. The perspective is on our platform, sir. So,
yeah.
Let's move, sir. Sir, the proposed amendment restricts a non-Muslim from creating a Waqf. Do you agree with this new change?
Actually, this is an Islamic affair, Waqf. So I doubt whether many Hindus are going to dedicate their property for Waqf. So it's not a major issue, in my view. But if the parliament has chosen to bring it, it's all fine. Either way, it's fine. I don't think any Hindus, even if there is a provision, the Hindus will not do it, then it becomes a paper provision.
Yes, sir. So the new bill adds that Waqf al-Awlad must not result in the denial of inheritance rights to the donor's heir, including the women. So is it crucial? Is it a crucial amendment in securing inheritance rights?
Yeah, that's important. That's important. That's a part of gender justice.
Mm-hmm.
It's a good provision. Because ultimately this Waqf al-Awlad is more like a will.
Yes.
I have created a Waqf, but for my Awlad. So why should the women be excluded from it? I'm all in favor of women being made equal sharers with the men folks of the family, whether it is even amongst Hindus in the rural area, their entitlement should be enforced. So in every sphere, they should have equality.
Moving on, so the new bill is doing away with the provisions giving finality, as you discussed before, to the Waqf Tribunal's decision. So now that the same can be appealed in High Court, what do you think about that?
Yeah, that's it. These are good steps. As I said earlier, that these are the changes which they are bringing are all good. But unless you tackle the definition of Waqf, these are only procedural things.
Yes, sir.
So these are relatively small steps. We must tackle the major problem of Waqf. Instead of getting entangled in these smaller aspects, the major aspect should be tackled. The grant and they should be, once that is taken away, automatically the main issue is resolved. And these are small steps in the right direction, but of course it is in the right direction.
So, what are your views on inclusion of the non-Muslim members in the Central Waqf Council and the state Waqf boards? How will that help?
So that's again, as I said, is not a major thing. There's no need for non-Muslims to be a party to the Waqf Council or to the Waqf Board. See, the problem is arising. If you are not changing the definition of Waqf, then this becomes necessary. Because if the Waqf Board has the power to declare my property, the property belonging to the Hindus, a Waqf property, then non-Hindus must be members. So I would say all depends upon whether the parliament is willing to change the definition of Waqf. If you are changing it and confining it to the Waqf created by the Muslims of India today out of their own property, then Hindus need not be. But if you are not changing the definition, then the property of Hindus are in grave danger. The property of government is in grave danger. Public property of public body is in grave danger. Then people from those communities have to be a part of the board.
So the proposed amendment also curtails the power of the Waqf Board to decide whether property is a Waqf or not and confers the power to the Revenue Authority. Do you think the criticism of this proposal is valid?
See, so why should there be any criticism? It's a question of forum. Why should the Waqf board or the Waqf tribunal decide and create havoc? This is complete chaos, and the Waqf boards have been creating havoc, appropriating property of whole villages, public property, farmers and city dwellers. So it is good that the power has been given to the revenue.
So do you think the present Waqf Act violates the constitutional principles of secularism? And what will be the long-term impact if the proposed amendments are not passed by the parliament now?
See, as I told you from the beginning, there is hostile discrimination between the acts relating to the religious and charitable trusts created by different communities. So obviously, there is a serious problem with this. Other problems I have pointed out. So if the present bill with the further amendments is not made an act, then the havoc which is happening, the chaos which is happening will continue. And that will be very bad for the society. So it is time that all parliamentarians and all parties get together and make suitable changes in the right direction. Especially the one which I have said, that these grants of the conquerors and invaders and their governors and the common land which has been included, that should be undone.
So we have reached the end of the interview.
Thank you.